Hello and welcome to another of the Family Law in Partnership series of comparative law podcasts. I'm joined today by Lavanya Regunathan Fischer, who's an Indian lawyer, and we're going to chat about the differences between English and Indian law, which I hope will be interesting. So, first of all, Lavanya, thank you very much for joining me today. It's lovely to see you. Where are you today? I know you work in between Germany and India, don't you?
Yes, so I'm in the Black Forest at the moment.
Lovely.
In a little town called Aachen.
Smashing. Okay. But you practice exclusively in Indian law, is that right?
Yes.
Okay. Well, look, I know we had a chat before and it was really interesting. So I'm interested to hear what you have to say about various things. But I guess the first one perhaps is to think about when divorce proceedings can be started in India. If someone wants to get a divorce in India, how do they establish their ability to do that?
Right. So I think what you're asking is it as simple as in England or is it more complicated? I think it's a little bit more complicated because you would have to speak with a lawyer. I think, yes, as far as I understand, in England, it's a form. In India, you would have to file proceedings. So petition would have to be drafted and it would have to be filed by a lawyer.
Okay. Yes, I mean, ours is really simple these days. It's all done online. So we have an online portal and people can start divorce proceedings very easily, perhaps too easily, I don't know. But there we are. And do you need to be living in India in order to have a divorce there? Or?
Well, you need to prove a link to India. So we have a huge diaspora. So it's also possible to show that you are Indian origin or you're an Indian citizen, but non-resident. So there are multiple ways to claim links to India. And you could file if you could prove, firstly, that India is the right jurisdiction to file, so it's the court closest to you, or that Indian law would have to be taken into consideration and you're not confident that the foreign court would do so. So there are a couple of ways in which one could file in India.
Right, I see. Okay. And is divorce, what are the grounds for divorce? Is it a fault-based or a no-fault system?
Yes. India does not believe in irretrievable breakdown of marriage. So you would have to have mutual consent or fault for the divorce.
Right. Okay. And I think you said something to me about whether if a divorce, an overseas divorce, is dealt with on the basis of retrievable breakdown, it might not be recognised in India. Is that?
Yes. So recently the court has become a little bit more relaxed in applying this, this principle or section.
Mm-hmm.
If there are extenuating circumstances, I think there was one case where the court accepted that irretrievable breakdown could be a grounds for divorce. But in India, usually it has to be a fault-based divorce. So we have to create the fiction of conflict.
Yes. We're very used to. We used to do that here as well. Of course, we'd have to come up with fault grounds if people would get divorced.
Yeah.
The system here now, though, is entirely no fault, as I'm sure you know, and so it's simply a case of confirming that the marriage is irretrievably broken down, which is interesting because obviously we have lots of Indian people in the UK. Is there a risk then that a divorce that takes place in England for an Indian couple isn't recognised in India?
Yes, I think it's very useful to say that Indian law has been considered. As you know, India has both secular laws, so to speak, and religious personal laws as well. So it's important to first identify whether the parties got married in India, whether they got married under a religious ceremony law, or whether they got married under non-religious, statutory provisions.
I see.
And so if it's the Special Marriage Act, for example, they could get married and divorced using a court-based system, whereas if it's a Hindu marriage or a Muslim marriage or a Christian marriage, you would have to make sure that Indian law governing these religious unions would have to be considered, and the court explicitly states that Indian law has been considered and taken into account.
That's interesting. And so how you get married is really important to how you get divorced. Okay. So again, very differently to the way things operate here. Well, I mean, one of the things that I often say to people will often say to me, oh, well, I got married there, therefore surely we have to get divorced there. And I'm always saying, well, actually that's largely irrelevant from an English perspective where you got married. But it sounds like in India, not only where you got married, but how you got married is really important in terms of the law when it comes to divorce.
Well, I would say that how you got married is important.
Right.
Where you got married may be less important.
Okay, I see. All right. And so there are different religious courts in India, are there?
Yes. Well, there's only one court,
Okay.
but the court applies different laws on the individuals.
Depending on,
Yes. So,
okay. And
yeah.
what if then if a couple is come from two different religions?
So you could choose to get married under religious law if the religious law allows it, or you could choose to get married under the secular law. Interestingly enough, till recently, the secular law required you to take parental permission and get a no objection from the parents, which made the parents very happy, but obviously the young people involved, or the people involved, were not so
Yeah.
excited about it. Yes.
So you had to get parental consent irrespective of ages.
Yes.
Wow.
I think it was meant to keep, social harmony, and we are balancing. There's a fine line between religious permission, family permission, to make sure. And in India, marriage is also a community affair. Everyone's involved. So I think these are all evidences of.
Well, that's certainly what we see. The big events, Indian weddings.
Yes.
Lots of they look like a lot of fun, but perhaps divorce not so much. So, and how are financial claims on divorce dealt with in India? Or again, does that vary depending on which system you're in?
Yeah, so there's no simple answer for that. It varies on which system. So precedent has ensured that there is at least a certain equitable basis in how maintenance orders are made, and assessment of property is done. There is no community, property concept except in Goa in India. However, the judge always tries to strike a balance between what is required and the capacity of the people involved to earn or to generate income for themselves. So again, the role of the judge is quite important in Indian family law.
Yes, absolutely. So, I mean, there sounds like some similarities with English law, certainly in the needs respect, because as you may know, needs is a sort of core concept of financial remedy claims on divorce in England, because looking at what each person needs, and most importantly children need, is central. We do though have a system that's developed from case law, which is where we differentiate between matrimonial and non-matrimonial property, which broadly speaking is, what you build up together is matrimonial. What comes in from an external source, or you have at the beginning, is non-matrimonial, and there's an entitlement to share in matrimonial property, but not non-matrimonial. And then we have complications of this concept of matrimonialization of non-matrimonial assets, which is slightly odd. But so if you're in a wealthy family, so if your couple is wealthy, what happens then on divorce? Do they divide the assets that they have? You say there's no community of property. Is it entirely needs-based, or is there a sort of fair division or equitable division of what the assets are?
Podcasts on Indian family law could take years because, again, the answer here is quite complicated. You see,
Right.
whether you're wealthy or not, Hindu law allows for Hindu undivided family property as well. Now, this means that property that is proven to be ancestral property would flow down the family succession route, which means that there are certain types of property that could not so easily be taken into the matrimonial pool of assets, so to speak.
Okay.
But the court has steadily been whittling this down in favor of a more clear division of assets. However, this issue remains. And I think years ago, the courts ordered couples to make financial disclosures in a form-based manner so that it was exhaustive and there was no room for perjury or not disclosing assets.
Okay.
And the punishment for that was prison. So it was quite a harsh, and these are court, late guidelines. The benefit of this is that it is possible to get a reasonably clear picture of the assets. In Hindu families, it may be more complicated, but you could always petition the court to ask for disclosure. But it's not easy, and yes, it would be a challenge to get the information if it is family property.
Right.
And, not titled with individual titles. And also, property that is in the name of the owner, the understanding is that they are the owner, the complete owner of that property.
I see.
So one would have to make the argument and convince the judge that you have some claim, or one has a claim to that property.
Right. And those sort of claims, how do they come about? Is that, do you need to make a contribution or an agreement to share, or can it sometimes be simply because you've been married a long time?
It could be that you've been married or that you've been living together and you could have a right of residence in that property. Traditionally, wives have been allowed right of residence even in ancestral property if they've been living there for a while or if they do not have anywhere else to go. So there are multiple issues that the judge takes into consideration. And here again, I find it really interesting because it's a very investigative approach. It's not just disclosure and decision based on disclosure. It's also the judge is in the center and kind of has to ascertain the relationship and the structure of that relationship.
Oh, interesting. Okay. And you were talking, I think, about Hindu divorces.
Yes.
What other religious divorces do you have in India?
So you have the Hindu marriage and divorce. A marriage is considered as a sacrament, so it's not a contract, which also has traditionally affected the legitimacy or recognition of prenuptial agreements. In Muslim law, marriage is a contract, so the nikah-nama, functions as a sort of a contract of marriage. Under Christian law, there's the Christian acts of marriage and divorce,
Right.
and so they have their own specific rules. So yes, you have a variety. You can choose which law you would like.
But I got that's really fascinating. And so are the outcomes quite different in these different courts, or do they sort of follow a theme?
Well, you see, every case is individual. We do have a very strong law of precedent. So if the facts are similar, subordinate courts have to follow sort of the line of reasoning of the appellate courts. But they're all statutory, so they're all act-based. So you can predict outcomes to that extent. But of course, every single case is different, and it also depends on the quality of the arguments.
Yeah, and that's interesting. You say it's statute-based, therefore you can predict. Because again, one of the things I often say with English law, I mean, our financial claims on divorce are statute-based, but reading this statute, you'd never be able to tell what the outcome is going to be. It's because it's old. Ours is the Matrimonial Causes Act 1973. It's not been changed since. And so all of the developments have come from case law. So all these concepts of matrimonial and non-matrimonial property, non-discrimination, all of that comes out of case law. But you're saying from the statutes in India that they're clearer in terms of likely outcomes. Are they?
Well, no, I'm not saying they're clearer. I'm saying that they exist. You see,
Right.
it's not that people sit around in a drawing room of an evening and decide how to divide the family property and, state that the couple is now separated and this is a divorce recognized in law. There are rules of procedure and the processes are clear and statute-based. But the religious law itself is different based on different religions. And Hindu law has a codified sort of structure for marriage and divorce. But this is not true of the other laws. So there are rules of procedure, but, the religious component may be quite discretionary. So it depends on which religion, how, what. There's lots of discretion and yes, grey areas everywhere.
Absolutely fascinating.
Yes, but I find in the opinions that I have given to English courts that English courts do take into account this kind of personal community-based understandings as well when they are talking about marriages and divorce. So I think the pluralism that is inherent in India's legal traditions are spilling out into the other jurisdictions as well, which are not so pluralist in their structure.
Yes, no, interesting. And so as I say, we've got lots of Indian people living in the UK, which is great. There must be circumstances where people are arguing where they want to get divorced. We often have those cases, don't we, where people say, where am I going to do better? If an Indian couple living in the UK wants to get divorced in India, it sounds like they can. There's the ability if they're link to India. And I guess so they could also potentially issue proceedings here if they're certainly if they're habitually resident here. When it comes to choice of court, if there is an issue about whether it's in India or in England, how does the Indian court deal with that if there's a jurisdiction raised?
So it's the court which is closest to the couple. And of course, this is especially true for cases where there are children involved, because the best interest principle, where's the child, all of that would also be taken into consideration. So it's the court that's closest. And first filing matters if you can't prove, for example, if a couple's been living in the UK for 2 years and one of them says, look, my links and roots are in India. I've been living in India for 25 years. So which is the court that is closer to me?
Okay.
I'm not a British citizen. I'm an Indian citizen. I just have residence in the UK. So there are different permutations and combinations for that.
Okay.
But the Indian court would look at jurisdiction, would look to see if the couple have submitted to that jurisdiction. So if one of them has not submitted to jurisdiction, there would be a dispute there. So one would be whether they have submitted, whether it is of competent jurisdiction, whether Indian law is capable of being taken into account. And there is this nebulous cloud of public policy. So
Right.
if it's not against public policy, whatever it may be, then it is possible for an Indian origin or Indian couple or one person being Indian to file in England and be successful. They could also file in India if, for the same reasons, if they submit, if they feel India is closer. But the Indian courts have been very strict on forum shopping. So if they feel that one of the persons in the marriage or in the divorce proceedings is filing to gain some sort of advantage over the other, they would take a very strict view of that.
That's interesting because, often that's the very reason, isn't it, that people
Yes.
choose a jurisdiction or choose a
Yes.
country to divorce in, because they think they're going to do better. So that goes against you in India if that's your reason for divorcing them.
Yes. If you have been living abroad for 15 years and you want to file just because you want to make it difficult for your spouse to attend proceedings, or you feel that you're going to have a better deal in India despite not having lived in India for the longest time, or if the children are settled abroad and are comfortable, yes, these factors would weigh with the
That's
judge.
interesting. I mean, we operate a similar system, and it's weighing up, where the balance of convenience is.
Yes,
So
exactly.
there are some similarities between the system. It's where you are, where you're most closely connected to.
Yes.
That's really interesting. What about pre and post nups? Are they enforceable in India?
Traditionally not, but again, the courts will take it into consideration. They will look at the educational status of both parties, whether one was manifestly weaker than the other at the time of signing. And again, it has to be in line with Indian law. So it would be a consideration, but it would not be automatically enforceable.
Okay. Well, perhaps not too dissimilar from England.
Yes.
We also take them into account, as you probably know, but they're not. And provided people have legal advice, financial disclosure,
Yes.
they're really important. And really, really importantly, an English agreement has to meet needs. Otherwise, it's not worth anything. And needs, of course, can vary from couple to couple. It can be very little for a couple that are not used to having very much, or huge amounts for
Yes.
extravagantly wealthy people.
I think the bottom line is that while we've tried to keep this overview simple, every case has an exception. Because there are so many laws and so many rules. I think what I would like to kind of leave you with is sort of to try and confirm that India has a very strong rule of law based structure, and it's not just community law or customary law that is just being applied willy-nilly. There is a judge. There are formal courts that are looking into these arrangements, and legal sanctity is only obtained if you go through a formal process. So that's one thing one shouldn't worry about.
Okay, well that's good. And I know what really interests you, Lavanya, is children, isn't it? Children.
Yes.
Is your thing. So how do the Indian courts deal with issues about children?
I think they deal with it. There's backlog. There are all of these things, but Indian courts are keeping to the best interests of the child policy. We are not a signatory to the Hague Convention of Child Abduction. However, the judges try again as far as possible to ensure that the child is placed with the parent best suited to them, and they do not automatically send the child back. However, if they feel that there is a case to be made, the children have been sent back, and absconding parents have been asked to return to the jurisdiction where the orders were made, the first orders were made.
I see. That's interesting. In terms of where children are going to live, if it's a case that's taking place in India, is there a preference between mothers and fathers, or is it gender neutral?
Yes, there is a preference, especially in the first district courts and things like that. And there are lots of lawyers who are frustrated with orders as well, but there are also lawyers who are happy that the judge kind of tries their best to check whether the child's interests are being protected. And it might appear again that there is a bias, but sometimes it's just the way it is.
Interesting. Okay. And I guess the final bit before perhaps I let you go is people who live together who are not married, do they have any rights in India?
Yes. So if if they've lived long enough together, or if they have a relationship akin to marriage, whatever that might be, the courts will make the presumption that they're married, and will give them the rights of a married couple. However, there are again tests, how long, how does the society around you view you? So it's again a very investigative process. But now states have started enacting live-in relationship acts to protect persons within this. The Domestic Violence Act also allows for live-in relationships to be recognized as possible source of domestic violence.
Fascinating, because England is way behind in many places in that respect. Certainly in terms of domestic violence, you can make a claim as a cohabitant, but otherwise relationships are largely not recognised. You certainly can't make a financial claim as a consequence of living with someone, unless you've got children. You can make claims on their behalf, of course.
Yes. In India, it's always been the presumption of marriage if you've lived together for any length of time. Yes, there is... Yeah.
That's good, I think.
Some good things. Yeah, I think so too.
Well, look, thank you so much for joining me today.
Thank you.
It's been an absolutely fascinating discussion. So, Lavanya, thank you.
Raised as many questions as it's answered, so thank you.
But that's a good thing. Thanks.
Thank you.